Sabarimala temple in Kerala will be open to the public for the first time after the Supreme Court verdict that allowed entry of women from the age group of 10 to 50, menstruating women to be particular, into the temple. So, as we already know, the protests have broken out at the base camp from where a 5-kilometer trek, devotees undertake a 5-kilometer trek to enter the temple. Reporters, there are several political and religious groups protesting, and they've all said that they will not allow women to enter the temple in spite of the Supreme Court ban. Now, at the heart of the controversy is ruling. The temple, the Devaswam board and the government have been saying that they are willing to implement the court order, and they will ensure that women who choose to go to the temple will be allowed to go without any restrictions. However, political parties have made this an opportunity and have created a situation where they've said the campaign, the Save Sabarimala campaign, has taken off for the last few days, and they've all said that women will not be allowed. So in less than an hour, we'll know what the security situation is at Sabarimala. So, but before that, let's discuss the controversial ruling, so to say. The fundamental question here that everyone's asking is whether courts can interfere with religion. Was the Supreme Court right in allowing women, menstruating women, to enter the Sabarimala temple when Hindu groups and the temple have protested against this and have said that there is an age-old tradition which prohibits women in this age group from allowing the temple. So legally, just to simplify, there are two quick points that we need to understand here. One is, unlike in the US, in India, courts and the state do interact with the religion in a very deep, significant way. And the reason for that is just simple, it's caste. So when our constitution was framed, and after that, untouchability and prohibition of certain castes into these temples was a big reality. So there were a number of legislations which took over the Hindu temples, declared them public properties, and allowed all sorts of castes, creed, and said that they can't be any discrimination based on this. So temple entry in India has been a big flashpoint, and this is where the courts really get to sort of interfere with religion and make that make that an issue which is coming under judicial review. So in Kerala, for this particular instance, what the statute that we go back to is the Kerala authorization of temple entry, which dates back to 1965. This legislation, this piece of legislation, categorically allows all sorts of communities and bars any discrimination in as much as allowing them into a temple. Remember that agitations have taken place in Kerala way back in the 1930s, where the royal family did accede to some of the demands and allowed the lower caste, particularly the Dalits, into these temples. So what comes to memory is the Vaikom Satyagraha, which sort of later inspired even Mahatma Gandhi in his future satyagrahas. So temple entry is really, the caste issue really is where the courts step in, and in that sense, in that limited space, regulates religion. Because Hindu religion did prohibit a number of sects from from entering these temples. So legally speaking, the issue before the Supreme Court was simple. We have a piece of legislation that says any caste, any creed anybody can enter these temples. And in the same Kerala Hindu Temple Entry Act, there was a particular exception that they had made for the Sabarimala temple. So the court had to really look into whether this exception was tenable when the intention of the legislation itself is to allow everyone into to these temples. And the second big issue is the constitutional provision, Article 17 of the Constitution, which prohibits untouchability. It is the fundamental right of every citizen to not be treated as an untouchable, to be given that equal space. So when we again talk about untouchability, the fundamental aspect is how do we look at untouchability? What we understand is when a certain caste is eliminated, is put aside, it's based on some notions of purity. And these notions of purity don't necessarily have to be caste based. The court essentially said that these notions of purity can be applied on multiple counts. For example, menstruation in this case. The reason why women are not allowed into temples while they are menstruating, and in this particular Sabarimala case, that entire age group is sort of kept aside because menstruation is considered impure and there are notions of purity attached to it. So the court looked at these two provisions of law and said, is this ban sustainable? And and what happened from the Kerala, the temple board itself, is that they could not empirically prove that this was a custom that existed for, let's say times immemorial, and this was actually a religious tenet to keep women away, to keep women of this particular age group away from the temple. So when the temple board proved this, and when you had legal and constitutional provisions which said that women can't be barred from entering these temples, the court then took a stand and said, you have to allow women. There is no reason why women can't go. So at the heart of the entire Sabarimala controversy is this court ruling. So for a very long time, the Kerala government hadn't taken a stand, had been dilly-dallying. Successive governments have shied away from saying openly whether they support this or not. In 2016, the left government, when the Supreme Court specifically asked Pinarayi Vijayan's government whether they support such a ban, they did come forward and they said that they will stand for gender equality. So the court's ruling is there. The temple has not decided whether it wants to file a review petition. Remember that a review petition is again filed on very narrow grounds, and it's highly unlikely that the Supreme Court could overturn the ban. So we have this 1 hour now where it becomes the state government's responsibility to ensure that the court's orders are followed. So this is the situation now, and as we can see, the protests are going on in Sabarimala at this point of time. Politically, it is a tricky situation. You have the left government on one hand saying that they will allow this, and you have BJP and Hindu outfits which are saying that this is a strike against the religion and this is courts interfering with the support of the government in how they conduct their religious affairs. So we're also taking questions live. So please do send in your questions, and we'll be happy to answer them. So we already have a first question, and this is from Anand. The question goes: despite a Supreme Court ruling to allow women of all ages into Sabarimala, women are getting attacked. Police is nowhere to be found. Can the court take cognizance? Does the court have no power to get its orders implemented? So when a court order is issued, especially the Supreme Court rulings, it becomes law of the land, and it becomes the responsibility of the government to implement these orders. So the state government, the onus is really on the state government, which and policing of course is a state subject. So it is entirely for the Kerala government to control the situation and ensure that the court orders are implemented. So how will the court get its own orders implemented? It is through the government. So if in a case where women cannot go to the temple, despite the ruling, despite the state government's interference, they can go ahead and file a contempt of court, and then the government will be called into question. So all focus is right now on the Kerala government and how they handle this situation. We saw yesterday that the Chief Minister, before heading off to a foreign visit, categorically said that his government will ensure that the court orders are implemented. Given that Kerala's political situation right now, where communal tensions are flaring, this is a very, very important issue. The opposition is attacking the government, and especially because the issue is relating to religious organizations and how Hindus conduct their own affairs. It has become a politically tricky situation for the Chief Minister. We have a second question, and this is from Ruhi Tiwari, and she's asking, does the Sabarimala controversy and the Supreme Court's liberal judgment give further fodder to the left and BJP's politics in Kerala? So first of all, the question we need to look at is whether the Sabarimala case is a religious case or simply a case of gender equality for the court. We've had such rulings in the past where the court has stepped into religious domains. Like I said, when there is a question of equality, the court does have a mandate to step in. We saw that in 2017 in the Triple Talaq case, where despite a pushback from the Muslim organizations that Triple Talaq is personal law and the religion itself will regulate it, the court stepped in and gave a ruling that triple talaq is unconstitutional. So the Supreme Court stands in that sense is consistent, and whether this gives fodder, absolutely it does give fodder. We also saw in the Hadia case when the issue of love jihad, so-called love jihad, was being discussed. It became a very important political conversation in Kerala, where the BJP had been talking about this narrative that Hindu girls and even Christian girls were being brainwashed by Muslim men, and they were being married off to Muslim men, and there were forcible conversions involved. So given the situation in Kerala right now, where the political parties are using unity, and with the Lok Sabha elections not very far away, this is a very big conversation in Kerala. We have another question, and the third question is, what happens if the women are still stopped from entering the temple or are in fact attacked? Is there any direction from the court on how to enforce the order? If not, what punishment will it invite? We've already discussed this in parts. The onus is on the government to get the court's orders implemented. For the Supreme Court, it does not become, the Supreme Court orders cannot be given based on whether the order will be implementable, easy to be implemented, or difficult to be implemented. When an order comes from the court, the Constitution says that every Supreme Court ruling is law of the land, and the government is bound to follow it. So it's really for the government to control this situation. As we know already, we've been seeing news reports that they've detained hundreds of protesters, including Rahul Ishwar, the social activist, has been detained. They are arresting some people who are causing trouble. Although despite that, we know that at least 2 journalist groups have been attacked. So we still have some time to go, and it is up to the state government to have a plan of action to get the situation under control. Our next question is from Deeksha, and the question is, does Sabarimala demonstrate judgments from the top court alone cannot orchestrate tangible societal change, or is it the case of poor implementation? I don't think it is anybody's case that the Supreme Court's rulings itself are enough to bring a tangible social change in terms of any law, let alone religion or anything like that. So laws are one part of it. It is the political will. It is what the situation is. And what we are seeing in Kerala right now is a combination of both. Although the state government here is, on board with the Supreme Court order, the state government has also said that they will not seek a review of the court judgment, and they want gender equality, and they will implement the court's decision. What you are seeing is a situation where there are political groups and social groups which are opposing the order. This ruling is never the last word on anything. Although legally, yes, it binds the government. You can hold the government can hold the government accountable. But it's really in the larger scheme of things, it's just one part that the court ruling is. Our next question is from Ratnadeep, and Ratnadeep is asking, isn't right to practice one's religion a fundamental right of the Indian Constitution? Absolutely. Right to practice religion is a fundamental right, and we must remember that this right is not restricted only to men or only to women. When women's groups, when the PIL petitioners went to the court, what they were seeking is implementation of this fundamental right to practice their own religion for all women. So again, we need to go back to what our laws say on this particular subject. Abolition of untouchability, throwing open Hindu temples to all sections of the society has been one of the key themes of our constitution. So if you look at the constitution, although it safeguards a lot of rights for religious denominations, it also says that untouchability cannot exist, and there are public places which includes temples, temple ponds and areas around it, which are all considered public places, and they are thrown open to the public. In these spaces, there cannot be restriction. So, but while we are talking about whether our constitution allows religious freedom, we should also look at another key provision of our constitution, which is Article 26. It gives religious denominations a certain sense of, a certain other set of rights here. Denominations are smaller sects in the it's not a religion in itself, but they're significantly different. They have a different ideology and a set of rules that exist governing their own practice. So those denominations are given a lot more freedom, like minorities are given. So one of the key issues in the Sabarimala hearing, when it was happening in the Supreme Court, was that the devotees of Lord Ayyappa said they formed a denomination. The Ayyappans, as they called themselves, were a denomination. The majority ruling of the court dismissed this proposition and said it is still as much a Hindu temple as it is the Sabarimala. So Ayyappans are not a denomination in themselves. So to give an example of what denominations are, people who follow Madhvacharya, the sects, you have these 7 temples in Karnataka, the Udupi temples, they are a particular denomination. So when you are a denomination, based on the rights that you get, you can have your own rules on how to run your institutions. You can, in that sense, restrict movement of certain people into your mutts, or but these are not Hindu temples. The law is very clear. Hindu temples are public spaces and are open to everyone, including Sabarimala. We must remember that the Sabarimala temple as well does receive funds from the government. Devaswam board does report to the state government periodically. In fact, they have monthly meetings where they have to apprise the government of what they are doing. So Hindu temples, especially where there is a legislation, they are heavily regulated by the government. And it started because of the caste equations that existed in India. Although the situation on that front has moved on from what it was in the 50s, this is reason why courts or the state involves in religious functioning, especially with Hindu religion. So we have another question, ruling and the fallout politically. Again, this is a very important question. We already discussed about the Triple Talaq ruling. So even when the Triple Talaq ruling came out, there was a huge backlash from the Muslim community saying that this is personal law and the courts should not invade into the space of personal laws of religions. But what we must remember is, even in the case of Triple Talaq, what gives Triple Talaq the recognition is not the All India Muslim Personal Law Board or the Sharia itself, but because the Sharia is recognized through a legislation. We have the Sharia Act, which came into force way back in the 1920s. So when Triple Talaq was declared unconstitutional, the court simply had to read down one provision which in the Sharia Act which allowed Triple Talaq. So wherever there is a legislation, wherever there is a law that the parliament has made, the courts can exercise their powers and review these legislations. So even in the Sabarimala case, as we discussed, there is a law, the Kerala Hindu Places of Worship Act authorization and for entry, which dates back to 1965, which the court had to interpret. And even in the Triple Talaq case, they had to interpret the Sharia Act going back to the 1920s. The fallout even in Triple Talaq case was similar, even if they weren't protests of this nature. The ruling was criticized. The ruling was seen as invading into the personal space of invading into personal laws of religions. So we must remember that the court's view has again been sort of consistent in this area, that you are free to propagate your religion as long as you do not interfere with the constitutional rights of anybody else. In the case of Triple Talaq, what we saw was instant Triple Talaq, or pronouncing Triple Talaq at one go, was violating the right to equality of women. In Sabarimala, it's a similar case. So the backlash really is, what's on everyone's mind, including some legal experts who've commented on these two rulings, is that should the court interpret the constitution very strictly, or should they use a liberal language to say what the constitution really needs? So when the constitution says all forms of untouchability is impermissible, do they only talk about caste, or do they talk about really all sorts of untouchability? So again, in the Sabarimala ruling, what was really talked about was the dissenting opinion of the lone female judge, Justice Indu Malhotra, who agreed with the contentions of the temple board and said the courts should not interfere and the courts should not allow women to enter the Sabarimala shrine. So, but in we also have to remember the same judge, Indu Malhotra, in the 377 ruling where homosexuality was decriminalized, said that we should not look into just the letter of the law, but interpret the constitution liberally to give effect to what it really means. So when the constitution says untouchability is impermissible, it is untouchability on all counts and not just limited to caste. So in the Sabarimala ruling, that's what they say, and because menstruation is sort of based on these puritanical notions of that a woman is impure while she's menstruating, that had been said that it was unconstitutional. So this is really the crux of the Sabarimala debate. In about an hour, we will know whether the Supreme Court ruling that was delivered exactly a month ago, on September 18th, will in fact be given its real teeth, and whether women will have the right finally to enter the Sabarimala temple. Do keep watching this space. We will be back tomorrow with another set of questions and a topic of conversation. Thank you for watching.